Hello and a warm welcome to World This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal Joon, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, in a notable observation, the Supreme Court has asked the centre and states to take instances of hate speech seriously and observed that it was nothing short of menace that it left unchecked and could become a monster. Hearing a batch of petitions highlighting inaction by states enacting against instances of hate speech made against Muslims and Christians, a bench of Justice K.M. Joseph and Justice B.V. Nagaratna said that it is a complete menace and nothing short of it. We should all be careful about the seriousness of hate speech and not end up creating a Frankenstein's monster that will gobble us up, it added. The court reminded the states that any action against perpetrators of hate speech should be irrespective of the religion, as the crime is against the society, regardless of who the speaker is. This was a reiteration of the order passed by the court in the same issue in October last year, in which it directed states to register suo motu complaints on the hate speech. In another significant ruling, the Supreme Court has observed that any marriage between interfaith couples under the Hindu Marriage Act is void and only Hindus can marry under the same law. The court was adjudicating upon an appeal against the Telangana High Court order, wherein it refused to quash proceeding against the petitioner under Section 494 of the Indian Penal Code, a provision that provides for sentencing of a person who marries another person without divorcing the first spouse. The division bench of the Supreme Court, comprising of Justice M.R. Shah and Justice C.T. Ravikumar, has expounded that mere filing of the charge sheet after the release of a person under Section 167(2) of CRPC cannot be a ground to cancel the bail. The court, after analyzing several judicial precedents, observed that filing of the charge sheet on conclusion of the investigation, if a strong case is made out and on merits it is found that he has committed a non-bailable offence on the special reasons considering Section 437(5) and 439(2) CRPC over and above other grounds on which the bail to a person who is released on bail can be cancelled on merits. It was noted that there is no absolute bar on cancelling bail under Section 166(7)(2) CRPC. Another division bench of Justice M.R. Shah and Justice S. Ravindra Bhatt, while taking strong exception to Rajasthan High Court making observation on the merits of the case that was remanded to it for reconsideration of the death penalty awarded to a convict in POCSO and murder case, has observed that the same is against judicial discipline. The court asserted that judicial discipline requires that once the conviction was confirmed by a superior court, that too after hearing the accused, the High Court should not have thereafter made any comment on the merits of the case, more particularly when the conviction was specifically confirmed and the matter was remitted to the High Court only for the purpose of considering the sentence, namely whether death penalty or life sentence or any other appropriate sentence. The Supreme Court has reiterated that the process of criminal law cannot be utilized for arm twisting and money recovery, particularly while opposing the prayers for bail. The court was of the view that in a given case, the concession of pre-arrest bail or regular bail could be declined even if the accused has made payment of the money involved in the offer to make any payment conversely. In a given case, the concession of pre-arrest bail or regular bail could be granted irrespective of any payment or any offer of payment. Noting that recovery of money is essentially within the realm of civil proceedings, the court emphasized that ordinarily there is no justification in adopting such a course that for the purpose of being given the concession of pre-arrest bail, the person apprehending arrest ought to make payments. The Supreme Court has cautioned courts and tribunals against the use of information available on Wikipedia for legal dispute resolution. The bench, while reckoning that internet does provide free knowledge, also asked the courts and tribunals to impress upon counsels to avoid using Wikipedia and alike sources and rather opt for more authentic ones. Noting that Wikipedia, the online encyclopedia, is a crowdsourced one with user-oriented edits, the court took exception to reliance placed by Commissioner of Customs Appeals and Mumbai Custom Excise and Service Tax Appellate Tribunal on it. It said that Wikipedia is a treasure trove of knowledge, but because of its modeling, not fully reliable. Next we have Delhi High Court. The single-judge bench of Justice Pratibha M. Patil, while directing the Delhi government to amend the guidelines for issuance of marriage registration certificate, elucidating the eligibility criteria of marriage under the Special Marriage Act 1953 issued by the Revenue Department, held that a requirement of at least one party being a citizen of India is not required under the Special Marriage Act. The court stressed that centre must take expeditious steps for amendment of the guidelines and make the required changes to the e-portal to enable foreign nationals whose marriage are to be solemnized and registered in Delhi to apply online for the same. The Delhi High Court has held that annual confidential reports of the persons in the armed forces are confidential in nature and the same cannot be disclosed even after retirement. However, grading given to IO, RO and SRO can be only communicated after a period of 3 years from the date of retirement. The petition in present matter was filed challenging the order by the Central Information Commission rejecting the petitioner's RTI application. The Delhi High Court has significantly ruled that insurance company can recover MECT compensation amount from the father of the minor driver. The single judge bench of Justice Rekha Palli opined that when the parent of a minor children permit him or her to drive a motor vehicle, not only they put the lives of children in danger but also endanger the life of common citizens, and therefore all the liability cannot be fastened on the insurance company when it is evident that the terms of the insurance policy were breached by the minor driver himself. The division bench of Delhi High Court, consisting of Chief Justice Satish Chandra Sharma and Justice Subramaniam Prasad, reiterated that a remedy provided under Article 226 is not intended to supersede the modes of obtaining relief before a civil court or to deny defences legitimately open in such actions. Further, it was opined that writ courts, in the exercise of their writ jurisdiction, do not substitute their conclusion of the ones arrived by the expert bodies unless the decision is perverse. Now let's have an overview of other high courts. The Calcutta High Court has enunciated that infertility is not a ground for divorce. The court, while adjudicating upon revision petition filed by the High Court by the husband who sought for quashing of criminal charges against him, observed that abandoning one's wife in such a situation where the wife is undergoing severe mental and physical trauma amounts to cruelty. The court remarked that instead of being a pillar of strength for her, the husband rejected her to continuous cruelty by deserting her in times of need. The Madras High Court gave direction to the authorities to regulate the practice of conducting stage dramas and adil-padil programs in which there has been a frequent casting of tribal couples, that is, Kuravan Kurathi. The court acknowledged that this practice cannot be banned altogether. However, the authorities must ensure that the acts of obscenity and objectification of women must not be showcased. Further, if the person belonging to the Kuravan Kurathi community are not involved in the dance, then their names must not be used on social media platforms. The Bombay High Court has observed that lack of due diligence is not a ground to reject petition for adding relief which was already inbuilt into prayer clause. The court, while quashing and setting aside the impugn order insofar as it rejected the application under Order 1 Rule 10 of CPC, remarked that the suit was filed against only one of the trustees and therefore the application for addition of the other trustees and the trust would be necessarily required to be allowed. The Tripura High Court, while allowing a revision petition under Article 227 of the Constitution for quashing the order passed by the civil judge by which the trial court rejected the application filed by the petitioner under Order 9, Rule 7 CPC, observed that pendency of case for a long period of time alone cannot be a ground to reject an application. Moving on to miscellaneous news. After slinging opaqueness charges at existing judges selecting judges mechanism, the centre has written to the CGI D.Y. Chandrachud suggesting inclusion of government representatives in the 25-year-old Supreme Court created two-tiered collegium for infusion of transparency and public accountability into the selection process of Constitutional Court judges. Law Minister Kiran Rijiju's letter to the CGI is the latest in the series of criticism by constitutional authorities, including the Vice President and Lok Sabha Speaker, who have also accused the SC of often encroaching into the domain of the legislature. The Supreme Court has asked the centre to file a reply on petitions challenging the constitutional validity of exception to marital rape provided in the Penal Code. Solicitor General Tushar Mehta in the hearing said that the issue would have social ramification, and a few months ago they had asked the states to share their inputs on the matter. The Delhi High Court has asked the Delhi government of AAP to not delay any further appointment of public prosecutors, the vacancies for which are still lying pending. A division bench of Chief Justice Satish Chandra Sharma and Justice Subramaniam Prasad, while granting last opportunity to the AAP-led Delhi government to fill up the states, remarked that criminal justice system is already plagued with a huge backlog of cases, a challenge which can only be taken over if the vacancies of public prosecutor remain filled and the machinery keeps functioning. Asking the government to expedite the process, the court listed the matter for 14th February for further hearing. 5 months after severing his association with Bharat Pay, a company he founded, Bhavik Kolaria, has filed a case against his former partner Ashneer Grover, another co-founder looking to reclaim his shares in the company. The Supreme Court has agreed to hear petitions of Rapido, the bike taxi and auto aggregator, challenging the Bombay High Court order which directed it to stop operations in Maharashtra immediately as it does not have a license to operate bike taxi or rickshaw services. In the end, we have international news. Adidas has lost a trademark case it filed against the luxury brand Tommy Brownie, seeking to stop the American designer from using four stripes logo on its products. The sports clothing and accessory maker claimed that the luxury brand Tommy Brownie's logo, which has four stripes, was too similar to the Adidas signature three stripes trademark. Brownie's designs feature four horizontal parallel strips usually on the arm of the apparel. Adidas also sought $7.8 million in damages from Brownie, but the New York court ruled in the favor of the latter. Latif Afridi, former Pakistan Supreme Court Bar Association president and senior lawyer, has been shot dead inside the Peshawar High Court. The senior lawyer was sitting in the bar room with other lawyers when a gunman opened fire at him. Tesla investors have filed a class action lawsuit against Elon Musk over securities fraud. In the opening statement of the trial, the lawyers representing Tesla investors has said that the billionaire lied about securing the funding to take the EV company private back in 2018. The trial in absentia of Belarusian opposition leader has started in Minsk. The woman candidate who ran for presidency in 2020 faces charges including high treason, conspiracy to seize power, and creating and leading an extremist organization. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.